Even Representative Mosley, did you do your homework? No, we appreciate you being here. Representative Mosley is subbing today. We want to welcome her to committee. Okay, so we are going to get started. And today I will be accepting motions and amendments officially. So looking forward to the continued discussion. I have spent all of Monday after committee, well actually all day Monday, all day Tuesday, in addition trying to work with stakeholders to get this where we can get some agreement, and I think we have arrived. So we're going to see some changes than what we discussed on Monday, and I think if it's okay with everyone, I'm going to start with my amendment. I have 3 amendments. Jesse, is that correct? I have 3 amendments. Let's start with the amendment on the definition. So she'll pass that out. We'll talk about it, and then we'll do an, if we agree, then we'll do an amendment to accept the amendment. So we spent a lot of time debating reasonable suspicion on Monday. The district attorneys really have concerns about that word, because that phrase is only used in criminal in our code. And so to negotiate that, my amendment has presenting a substantial risk of serious harm. And I got my district attorney, Mark Bennett, who testified, to say he's closer to being probably neutral or a proponent with that. But I just kind of flung that on him yesterday, so he's still thinking about it. So this says presenting a substantial risk of harm. Jesse, do you want to go over this amendment, or while everybody's thinking about that, you can talk about what this amendment does?
Thank you, Madam Chair. The document in front of you is the amendment. So on the first page, this amendment will delete all references to imminent harm and make them serious harm. So you will see that that is a change we will need to make in the title for constitutional requirements. Page 4, at the very bottom in line 42, is where the definition of neglect begins. There you see some structure in regards to the definition, and we'll get to why later. So the bill currently strikes presenting a likelihood of harm. This amendment inserts or presenting a substantial risk of serious harm. Parent there is just for consistency purposes. And then where it says in the 4th line, the inability to provide for a child due to inadequate financial resources, that is moved up there to qualify that the inability to provide is due to the inadequate financial resources, as to there's no confusion on that qualifier of inadequate financial resources. In the shall not be limited to examples for neglect, the bill currently strikes failure. What the amendment does is it inserts unreasonable failure and then keeps in the underlying bill's insertion of refusal. So each of those would be unreasonable failure or refusal for all 3 instances. And number 2, or what will be B if the amendment is adopted, there is also where a likelihood of harm has been struck by the underlying bill, and this amendment inserts or presenting a substantial risk of serious harm to the child to match the above. And then lastly, there's a new subparagraph 2, which is causing the restructure within that neglect as it exists in the definition in 1 or A, B, and C of the amendment would include the cumulative effects of a pattern of conduct, behavior, or inaction on part of a parent, guardian, or person who is responsible for the care of a child. So the cumulative effects of behavior under this amendment would apply to all the other instances within the definition of neglect, and that is what the amendment before you does to the underlying bill.
Thank you so much. We did have that cumulative effect of a pattern in the actual definition and decided that we should make that its own section so that it applied to all three, now A, B, and C with this amendment. Okay, questions? Representative Neighbor.
Thank you, Madam Chair. This is a point of procedure questioning because you said we were going to work this, that we are working it or we're not working it. Because the question would be moving to pass this out for purposes of discussion. Because I don't think we can add to the bill unless we're working the bill. Can we?
Okay, it's chair's prerogative according to the reviser. So, I mean, we can. It's,
I just think we should have the body that we're working on. And then as we bring amendments to, if we're going to vote on these today, to go ahead and then vote on these one at a time. So whatever goes in, it has a bill to be in.
we will. I just wanted to have this discussion because it was different than what we talked about on Monday.
Okay,
So-
that still would be the same thing
Yes.
as working the
Yes, and the
bill.
revisers confirmed we don't need a motion right now.
Okay.
Yeah,
Thank you.
perfect, thank you. Okay, so is there any questions on the changes that, from what you saw on Monday to what you have right now? Representative Burkamp.
Thank you, Madam Chair. Doing a little bit of research, and like CAPTA from HHS uses imminent harm. So the federal government, it looks like they recommend at like imminent. Is that something that we've considered in the past or looked at?
Say that one more time.
So when I was just looking at research online, I think HHS has like guidance for states when it comes to this. And one of their, I think, suggestions was like an act or failure to act, which presents an imminent risk of serious harm. So I guess,
So this was in the original bill, it was imminent. The district attorneys in our state had very serious concerns with the word imminent. It was harm. The bill changed it to imminent, and that was one of the reasons they were in opposition, was because it was imminent. Because imminent means right now. And if there's not a danger right now, then they can't remove, even though they know maybe something, if it's imminent. Does that make sense? And so I compromised with serious harm. We want a little bit higher standard than harm, lower standard than imminent, and so serious is kind of where we ended up. Okay, that's a good question. Thank you. Other questions? Representative Humphries?
Thank you. Your, the amendment that we heard on Monday that had to do with, on page 9, section 3, on or after January 1st and so on, is that part of your new amendment, or this amendment still?
There's another amendment coming.
Okay, thank you.
I broke these out so that, for the purposes of discussion, so we could do little chunks at a time. Okay. So, good question. Representative Ousley.
Thank you. And if I might ask a question of the reviser for committee interest, the black definition of serious.
Yes, thank you, Madam Chair. Just a reminder for the committee, the word harm is defined for the code, and that would mean physical or psychological injury or damage. As far as the definition for serious, as defined by Black's Law Dictionary, it states when you're referencing an injury, illness, or accident, the definition is dangerous, semicolon, potentially resulting in death or other severe consequences.
Thank you. Okay, if we're clear on that, I would move that we pass this amendment out favorably to amend the bill. Thank you. I'm second by Representative Johnson. Okay, are there any additional questions now that we've had an official motion? Any further discussion? Representative Roser?
Thank you, Madam. Thank you, Madam Chair. Just for clarification, Can we go ahead and vote these other amendments that were different versions of, previous versions of this down, so we can like scratch it?
We don't have to vote them down. They were never, there was never a motion on them.
Okay, then I have another question.
Okay.
Since we keep coming back to the definition of harm and serious, could we add that as like, I don't know, GG or whatever's on page 6 then to this as well?
So I did discuss that with some of our district attorneys and our revisor. The courts will define that, but they will use, it is not defined in Kansas code of, the C code. So I don't know that we need to define it. Jesse, do you have an opinion on that? I'm sorry, what? It's a policy choice. We could, if the committee decided to do that, we could insert the Black's definition, we could come up with our own, or we could just leave it to the courts to decide that, and they would refer to Blacks.
Okay,
I
perfect.
think, yeah. Any other, I feel like an attorney. I think I need to get my law degree or something. Oh my goodness. Any other discussion on this first part? Okay, seeing none, the motion is to pass this out to amend the bill. All in favor, say aye. Aye. All opposed, nay. The ayes have it. The ayes appear to have it. The ayes have it. Okay, most amendment passes. Okay, so now for amendment number 2. I combined the amendment from Monday that you saw, 2 and 3. I combined that into one amendment. So the dates that Representative Humphreys asked is going to be in this amendment, along with the section that's based solely on. This is the part where imminent harm was used in the bill. We kept it consistent and put in substantial risk of serious harm. We did leave isolation in there after the discussion on Monday. And if, Jesse, do you want to cover this one? Thank you.
Thank you, Madam Chair. This amendment in the document in front of you does the following. So on page 8 in line 19, it says, the rest of the sentence of, shall demonstrate facts that allowing the child to remain in the home would be contrary to the welfare of the child, that placement is in the best interest of the child, and there is substantial risk of serious harm to the child if not removed from the home. So the facts demonstrated in a petition requesting removal of a child would have to have facts related to the substantial risk of serious harm to the child if not removed. Here the amendment is striking out such facts specified shall show a causal relationship on the particular conditions in the home, and then that imminent harm again is deleted. The next sentence would be facts demonstrating. There you see the deletion of imminent and insertion of serious. Harm shall not, and then instead of include any of the following alone, this is just reworded to say be based solely on. So facts demonstrating serious harm shall not be based solely on. And then that is where the list of factors are. There you can see in line 28, substance abuse is deleted. 29, prenatal drug or alcohol exposure is deleted. And in the place is inserted a non-felony drug crime without harm to be one of the factors. And then later, after the list of factors, you have B, which would require that including serious harm to the child in such petition may consider that such harm outweighs the harm to the child as a result of such requested removal. So when the petition requesting the removal for a child, it may include that an argument that the serious harm outweighs the harm to the child if the child were to be removed. Next, on page 9 is section 3. This is where it has the delayed effective date change that the committee saw on Monday. So here, this section would be effective on and after January 1st, 2026. And then on page 10, in line 23, you see a shall turn into a may. So this is when, if the court determines there's probable cause to enter an order of temporary custody, this new language would require the court to consider some new things, such as whether participation by parents or guardians in prevention services would prevent or eliminate the need for removal. The underlying bill requires that then the parent shall have the opportunity to consult with counsel prior to agreeing to any proposed services that are being discussed before a removal. That is, instead of a shall, there's a may, so there is an opportunity, but there's no requirement to have a parent consult. And then lastly, following line 32, you have that this subsection shall apply to proceedings filed on and after January 1, 2026. So when this goes into effect, there may be a case that has been filed on, December 31st, but here you have this change on January 1st. So this would not apply in that case. This would only apply in cases filed with the court after the January 1st date and have that prospective application. The section would also require the secretary to update policies in compliance with the subsection and the new requirements, and that the secretary submit copies of those policies to the Joint Committee on Child Welfare System Oversight on or before January 1st of 2026. And then on page 12 is just repealer cleanup in regards to that delayed effective date.
Okay, so the changes that we see is on page 8, non-felony, it did say non-felony substance abuse on Monday. We did change that to drug crime after talking to Ed Klump, because how do you know if it's substance abuse when they show up there? Substance use is one thing, but substance abuse is, they can't judge that. So he suggested non-felony drug crime, and that is defined in our statutes. And so that's why we changed it to drug crime as opposed to substance abuse. And then just made things consistent. The reporting, it was reporting to our committee, but then the Senate wouldn't really know. So I decided to put Joint Committee on Child Welfare because that is Senate and House together. The Senate does not really have a child welfare focused committee. And so it would either go to health or judiciary, and instead of trying to navigate all that, we just put joint committee. So those are the changes, other than substantial risk of serious harm and serious, that are on here. And the date. We just, it was really important to the DAs that DCF have time to get their policies updated, to get people notified of the changes, get the courts on board, the police on board, everybody notified of this new definition. And so we delayed it until the first of the year. Questions, Representative Roser?
Thank you, Madam Chair. So the date on page 10 to submit copies of the policies to the Joint Committee, it went from July 1st of 2026 back 6 months to January 1st of 2026. So we wanted to speed that up.
So the reason it was July 1st of 2026 is because this section isn't enacted, so we can't do a date prior to that. Okay. So, because we want the end of the year. I talked to Secretary Howard this morning. She's like, oh, we can have that out in the fall, which is great, but I can't require that in the bill because it can't start till January 1st of 2026. So we just put it in there 6 months after the enactment of this. And so when she said that she could get the policies out earlier, we changed it to on or before July 1st or January 1st.
Okay, so we moved it up, though.
We moved it up.
Calendar. And then on the first, or on page 8, your original amendment from Monday removed isolation.
Yes.
And we are not going to remove isolation anymore.
Right. After this discussion of the committee on Monday, I thought everybody was in agreement on leaving isolation, that it could not be based solely on isolation, thinking about the rural people that are on farms. Okay. Are we good? Okay.
Thank you,
Well,
Madam.
good questions. That's perfect. Representative Humphries.
I may have blinked when you said this, but did you mention about the prenatal drug or alcohol exposure?
I did not talk about that.
Okay, go ahead.
I combined Representative Humphreys into my amendment just for
Made
making
much
this
more sense to
faster.
do it that way.
Yes, so we are still removing prenatal drug and alcohol. That was Representative Humphreys' amendment, and I think we were all in agreement on that.
And could I just address one other thing real quickly?
Yes.
You know, we had a discussion with Representative Carr after the meeting on Monday about how, I think you changed the wording really to a much better language when you said can't be based solely on this, because when it was these alone, then it seemed like you could combine those together. But the way you put the new language, it's not the same, it doesn't come off the same way as it did before. So I think this is a great language and more clear and for what you intended. Thank you.
Great. That was DCF's suggestion, so that was great. Okay, any other questions on this part? Representative Johnson.
Thank you, Madam Chair. I had an opportunity to work quite a bit with the law enforcement component. Mr. Klemp represents the chiefs of police, the Kansas Sheriff's Association, and Kansas Police Officers Association, the three primary. The only one I have not talked with would have been the Highway Patrol, who are probably not impacted. And we have support from them now, and I think that was important. And one of the terms that was very critical was that term of imminent, which is very much a law enforcement term that we used in police work, and feeling that this is a social work type of an issue. So I do feel like we've made a very concentrated effort to work with that component on law enforcement. Thank you.
Okay, any other discussion? Do you want to mention that? Representative Owsley? Okay, Representative Owsley.
So, thank you, Madam Chair. We were having a sidebar conversation here on page 10, the striking the shall and including may on line 23. And at a glance, I don't think I like this change, but I understand the meaning of it, you know, behind it, that if a parent has been struggling and this could be used as a delay tactic, you know, that it could delay court hearings and be dragged out up to weeks. I'd be open for further discussion on this, but I don't think I'm going to get hung up on it.
And that was the reason it was requested to be from shall to may, because they don't want to delay. If a parent is in agreement and they're working to keep the child in the home, if they have to consult an attorney, it may delay. That's why we changed it to may. So if they want to consult, they can, you know, consult the attorney, but it's not have to, right? Representative Owsley.
And if that's the understanding and the intent of it, that, you know, they may upon request or whatnot, then not shall, then yeah, I got no problem with it, as long as somebody still has a right to an attorney.
Yes, I think they still have a right, but is that correct, Jesse? Do you read it that way? Do you want to?
Generally, under the code, parents have a right to an attorney during these proceedings.
Thank you for that clarification.
Okay, yes, that is important. We do not want to take that away. Okay, any other discussion? Okay. You good? No, you got another. Okay, I do. It's different. It's not about. Yeah, I'm getting ready to make a motion to finish this one. Okay, so I'm going to move that this, I don't know what to say. I make a motion to amend the bill with this amendment. Sorry, House Bill 2132 with the second amendment. Okay. Sorry, I wasn't expecting to make my own motions. I thought about all the other procedures, but not about making the motion. Okay, so all in favor?
You gotta have a second.
I need a second. Second by Representative Roser. Thank you. I saw it, I just didn't say it. Okay. Any other discussion? Questions? Okay, all in favor say aye. Aye. All opposed say nay. The ayes appear to have it. The ayes do have it. The amendment passes. Okay, for the third one. Okay, so this third amendment is new language, and it's a new part of the sync code. So what we realized is that in order to make neglect, the definition of neglect, to change that, we also had to take a look at the part of the law that deals with police protective custody, because these two cannot conflict. If police protective custody is removing for the old reason and they get to court, and that court is looking at the new reason, they may send these kids home. These kids were removed for 72 hours without a reason. So this amendment comes to us on behalf of a discussion that we had with Ed Klump, who worked really hard with us. A lot of this was his idea. So I'm going to get into this. I'm just going to try to talk my way through this, and Jesse can correct me. So in this section of law, it says a law enforcement officer or court services officer shall take. There were 4 shalls. You shall take into custody when these following things occur. What we realize is that 2 of them could be a may take them into custody. Those 2 may reasons are found in, I don't know what section, section C. No, B1, thank you. B1. So a law enforcement officer may take a child under 18 years of age into custody when the officer, 1, reasonably believes the child will be harmed if not immediately removed from the place of residence or residence where the child has been found, or 2, which will be number 2, reasonably believes the child is experiencing a behavioral health crisis or is likely to cause harm or self to others. Sometimes police officers can respond with another option than removal. And so what we wanted to do was give the officers that option. So taking that shall to a may for those 2 reasons only in this part of the law will give them the ability. Then we are going to add a law enforcement officers is the box at the bottom. A law enforcement officer shall explore other options to separate the child from the source of harm before removal of such child as provided in subsection B. Okay, I'm going to stop right there. So this was Ed Klump's idea and request for this language. Those other options that we're talking about, we did not want to put in statute, but it's the 4 questions that DCF has been asking us to use, or law enforcement to use, DCF workers to use before removal. Those 4 questions are: how can the danger be removed inside of the child? Can someone move into the home or remove the danger? Can the caregiver and child live with a relative or family friend to remove danger? Or could the child temporarily live with a relative or family friend? So that is the other options. Now there may be, we left it vague because locally, police may have some different options than they would statewide. So they can use their other options that are local to them as well. So we added that. And then the Part D says, this is new. And when we were talking yesterday, I realized we were missing a piece of the puzzle, and this, I believe, is part of that puzzle. So the secretary shall provide an electronic means of communication for a responding law enforcement officer to refer a child who may be a victim of abuse or neglect to the secretary. The secretary shall receive such referrals, determine whether to initiate an investigation or abuse or neglect, and within 24 hours of submission of such referral, respond to such law enforcement officer. What we're asking DCF to do, and I did talk with Secretary Howard this morning, and she is in favor of this, and I believe this is going to be a good tool. So law enforcement officers will have a dedicated response line, whether that's an email, submission form, something that will be just for police officers to use. and that they will get a response within 24 hours. So if a police officer is on a door without training in child welfare, right? They're just responding, and they are trying to determine, do I have to remove this child? Is that the only option? What if we could just get someone to respond the next day for follow-up? That's what this is for. So the officer can make the report, DCF will respond within 24 hours to follow up with this family to see what they can help with, what resources, maybe it's a FENA, a family in need of assessment, just to get some eyes, just to follow up with them. And then the rest of that is, Jesse can cover. That's the only two things I want to cover. You want to cover the rest of it?
Sure.
Okay.
Thank you, Madam Chair. So at the bottom in that box in paragraph or subsection E, you see a law enforcement officer shall take a child under 18 years of age into custody. That is just a reiteration of what's already existing law above. So subsection B was split into the two. These are the two ways a law officer may take a child, and then E is taking that existing language of when a law enforcement officer shall take a child, and those instances are when the law enforcement officer has probable cause to believe the child's a runaway, or on the missing persons register, or reasonably believes that a child's a victim of human trafficking. So that's where the shall take a child still applies in those two instances. And then as far as the amendment goes, there is some cleanup on B2, and then all of those references to subsection D will be changed to subsection E. So that's some cleanup I wanted to mention.
So this is a brand new amendment that you guys have not seen before. Is there questions or discussion on this? Representative Burkamp.
Thank you, Madam Chair. Probably splitting hairs, but after your first shall to may on the next point 1, does that need to be seriously harmed, or can that just remain harmed to be consistent with your amendment, your first amendment?
Revisor, Jesse. I mean, that's a good call, yes. I mean, we want to be consistent. Would neglect, just the definition of neglect, cover that?
So I believe these would be two different analyses, right? So when a child is to be determined to be a victim of neglect in a sync proceeding under the definition versus when a law enforcement officer may take a child. So they are two different points of analysis.
So could we change that to serious to be consistent? No, that's a good question. Okay. So we're in discussion right now, so we would amend the amendment once we get it, once the amendment passed, then we would amend that, correct? Okay, perfect. Okay, good. Any other questions? Representative Riley.
Thank you, Madam Chair. This is a revisor question. After you delete 2, 3, should 4 not become 2?
Yes, and that was some of the cleanup I mentioned.
Okay, thanks.
Representative Humphreys?
Okay, so I would vote against adding serious, just saying, because it just seems like what's serious and what's not. I mean, an officer at the moment is trying to make a decision, and it seems like adding an adjective there just makes it harder for him to decide. Harm's okay, but serious harm is not okay. Just, I like it, leaving it the way it has been. In the past, this is the way they've dealt with it. So just saying that. Okay, but then I do have one other question. Under A law enforcement or court services officer shall take a child. And then E is I mean, they both have shall take a child under the age of 18. Is the difference A is including a CSO and E is not?
Yes, and then the points of 1 and 2 are also different. So when the law enforcement officer and the court services officer shall take a child, it's when they have a court order or they have a cause to believe there's a court order. Whereas in E, a law enforcement officer only shall take when there's probable cause to believe that a child's a runaway or that a child's a victim of human trafficking.
I mean,
So,
yeah, I mean, at first I thought any, under 18, they shall take, we could put them all in one place. But the difference is there's the CSO up in the one. So I just wanted to see if that's what the difference was.
well, and the reasons for taking the child are different too.
Yeah, but they should all be listed. I was not saying they shouldn't be listed, but if we need to break them up, it's because it's different people that have the ability to do that. But that, I mean, I'm just was making sure that I understood that that's what the intention was an officer can do it in these cases, and an officer and a CSO officer can do it in these, or a CSO can do it in these. Okay, thank you.
And that wording didn't change from what it is right now. There was 3 sections before, or 4 sections before, I believe. In the statute now, there's 4 sections, A, B, C, and D. So we just, well, just for talking about removal, the shalls, just the shall part. E and F is different, right? Okay, yeah. Yes. Yeah.
It's fine. I just wanted to make sure that it was clear.
Okay. Any other questions, discussion? This one's new, so I'm going to give you a little bit of time to process. Representative Owsley.
Madam Chair, thank you. Do we want to have the discussion upon amending the amendment now, or do you want to?
We can do that now.
Because I think inserting the word serious goes with the spirit of the bill, and that, we're not going to be removing children because an oven's on, or, during discussions, we were talking about it, there's harm in everyday life, crossing the street at a crosswalk can still be harmful. So if that officer reasonably believes a child will be harmed, what's the level of harm that's worthy of removal? And I think at this point, we're talking about, we want to know that that child's safety is at risk, not just of harm. And I think the addition of serious provides that extra level of scrutiny or, officer discretion there that we're requesting with this bill. So I'd open for discussion.
Okay. Other thoughts?
So, Madam Chair, if I understood the conversation earlier, it would be B1
One.
would read, if we amended the amendment, reasonably believes the child will be seriously harmed, whereas currently it reads reasonable believes the child will be harmed. So it would be the addition of that one word.
Other thoughts? Representative Humphries?
Sorry. Not about that. So you can vote on the amendment to the amendment if that's what you wanted to do now. But I do have another question. Under this block, the big block that you're putting right after the little c, should one be struck out? Or is that going to go right after? I mean, my block is a little bit cut off, so there could be something underneath it that I can't see.
Sure. So what, starting at little parent C, you'll have little parent C, the language, and then little parent D, and then you'll have little parent E, and then under E you have 1 and 2, and then the next in cleanup should be F, and then you would keep the 1 and keep the 2 as is, and then where it's designated F should be G.
I see.
So yeah.
That, it should be F 1 and 2. Mm-hmm. Okay, thank
And
you.
then that F should be.
The F should be a G. Got it. Thank you. Okay. Thank you, Madam Chair.
Other discussions, questions? I've Heard from 3 on serious to harm. Okay, Representative Burkamp.
Thank you, Madam Chair. Since I started the whole thing, I apologize, but I would probably defer my judgment to Representative Humphries. I think she has more of a background than I do in this, so I trust her, I think, knowledge more so than mine, and I'd be fine not adding it, but not strong one way or another on it, so thank you.
Oh, and look at him. He just walked in the door. Would you mind standing for a question? And we'll catch you up while you get up there. I was just going to say, if Ed were only here and he walks in the door, this is great. So would you give him a copy of the amendment? Perfect, thank you. So this is talking about the police protective custody section. And because we moved everything around, it's kind of confusing a little bit. But what we're focused on right now is B1, where it says, so B says a law enforcement officer may take a child under 18 of age into custody when the officer, 1, reasonably believes the child will be harmed if not immediately removed from the place of residence where the child has been found. We're trying to decide if that should be serious harm, because that is what our definition of neglect is, or how that would impact officers, on the scene. So reasonably believes the child will be harmed, or should it be reasonably believes the child will be seriously harmed?
Well, I'm a person who likes consistency. I mean, the serious is new in the definition as well. And if that's going to be in there, then I would say it would make sense probably to put it in here as well, so the two statutes are consistent with each other. I mean, if the standard is going to be that, I mean, I don't worry about abuse cases so much because those are pretty clear cut on harm.
Yes.
It's the neglect cases that come into question.
So Jesse, are we talking about abuse and neglect in this number 1? Is it both that we're talking about both, right?
So when a law enforcement officer shall take a child under 18 years of age into custody, or what will be may if the amendment is adopted, this is an isolated analysis of that law enforcement in that taking of the child. And so they are limited to this reasonably believes the child will be harmed under this section. And then the analysis of whether that harm is abuse or neglect that would render a child to be a child in need of care is done later.
Okay. And I think serious harm would have definitely applied to abuse, and then it would be consistent with our definition. Would you agree with that, Mr. Klump?
If we're talking about physical harm, I would say yes. If we're talking about psychological harm, I think that's kind of different, and I think we have to address that a little differently. I think in those cases, we sometimes have time to get DCF involved and things like that, and I think that's normally the way we'd handle it. I would just point back up to A1, and we're talking about into custody as a child in need of care. So this statute, in our opinion, covers any time any kind of child in need of care under the Act would take place where we needed to act to provide safety for that child. So in our opinion, it would clearly cover both abuse and neglect.
And you think serious would make it consistent since we are changing the definition?
I like consistency. I think our officers like consistency. So if you're going to change it in one place, I think you should change it in both.
Okay, thank you. Okay, you can sit down. I'm so
Okay.
sorry. Thank you for being here.
Sure.
Perfect timing. Representative Esau.
Maybe it's afternoon and I just need caffeine. Where do we define serious harm or seriously harmed? Am I missing it? Because I know we define harm.
That was the first, we didn't define it. It's not defined. It's just substantial risk of serious harm.
So we
Is
don't
in the
define
definition
what
of
the
neglect.
level is. Okay.
Yeah. We do have
the
the Black's
Black's Law.
Law.
Thank you.
Yeah, we did talk about that,
I just wanted to make sure.
but it's not in the bill. That was serious. Black's Law, we talked about harm and then we defined serious out of Black's Law. Correct. Okay. Other This is good. Other questions or discussion before we make a motion? Okay. So I am going to make a motion that we amend House Bill 2132 and we include the word serious before harm in B1 and give Jesse the technical ability to clean that up. Representative Pickert?
Just to make the grammar correct, I think it needs to be seriously harmed.
Yes, that's why I gave Jesse the ability to clean that up. Okay, all in favor of, oh, is there a second? I need a second. Representative Johnson seconds. All in favor, say aye. Aye. All opposed, say no. The ayes appear to have it, the ayes do have it, and the amendment passes. Okay, I think that's all that I have. Are there other discussion on HB 2132? Representative Carr.
Thank you, Madam Chair. I will go back to page 8, where there was some discussion that came out earlier that Representative Humphreys brought to our attention, and we had this discussion, and I certainly felt better with my explanation before we went through all of this previous legal jargon. So what I'm going to do, because it sounded so much better when Jesse explained it, I know that we're on the same page, but I think I'll let Jesse explain that, and that way it'll be probably easier for everyone else to understand.
Committee, the amendment being brought forth in front of you is on page 8, and this relates to the facts to be specified in that petition requesting the removal of a child. So the underlying bill states that this list of facts shall not be solely alone in the petition. So with the bill you're looking at right now, it has been amended to be based solely on, and then what this amendment does is it adds based solely on, or if one of these factors is co-occurring with community or family poverty. So therefore, that would prohibit a petition requesting the removal of a child to have any of these factors in addition with community and family poverty, as to prohibit facts in the petition that would be crowding and or adequate housing and poverty, or substance abuse and poverty. So that two-factor, if it's with community or family poverty, cannot be in the petition to demonstrate that a child shall be removed.
Madam Chair, if I may.
Yes, you may.
So the intent here is so that we're not removing a child, and the foundational reason for the removal is poverty. So if you take poverty, you can combine it collectively with any one of those. Inadequate housing. The housing is quite likely inadequate because they simply couldn't afford to live in better housing. So the intent here is just to remove the fact or the idea that someone is living in an impoverished condition, and that being a foundational basis for you to identify any one of those other factors and remove a child.
Okay. Questions, discussion? Representative Riley.
To continue discussion, and I was part of that little discussion yesterday too, and so I want to second this to make this sure that we have a discussion on it, so I'll second this.
There wasn't a motion, so we're just discussing right now. So, okay, any discussion? Representative Burkamp?
Thank you, Madam Chair, and maybe Jesse can help me with this. So if we go back to section 1 of this part of the bill, subsection 1, so it talks about child in need of care. Does that, when it references poverty, does that cover some of this, or is that separate entirely from like neglect and abuse? Because it mentions it there, but so I don't know, like as we go on, how that relates to.
Yes, so when you think of section 1 of the bill and the definition of neglect, the definition is used throughout the code to determine whether the child who is the subject of a proceeding is neglected under that definition and therefore, shall be in custody of the secretary and removed from the home. In those proceedings, this section relates to that petition specifically that is requesting the removal of the child. And so in that petition, this part of the underlying bill that is proposed to be new is that in that petition requesting the removal of the child, the facts that are being demonstrated that the child is a victim of abuse or neglect shall not include any of these following alone. So these facts in the petition are being used and demonstrated to determine whether that child meets the definition of neglect in section 1.
Okay, and I think I follow, because like in section 1 too, it says not solely upon, so it kind of references that in a way. That's where I just, and probably should have asked that a week or two ago, but I was just reading it and wanted clarification, so thank you.
That's a good question. Other discussion? Representative Owsley?
Thank you, Madam Chair. And thank you for bringing this forward. I don't think that the extra added clarity is a bad thing at all. And when we were having the discussion on the First Amendment, I was recalling just a committee conversation yesterday. I was not a part of the discussion after committee yesterday. I was not counting heads, but I wanted to make sure there were not too many of us there. But I was thinking earlier that, because the conversation yesterday was crowded or inadequate housing compiled with community or family poverty. And I was thinking earlier you could just put crowded or inadequate housing due to community or family poverty. And I'm glad I didn't say anything because I think this covers our bases even more and just spells it out just that much clearer. So thank you. Thank you, Madam Chair.
Okay, so the question that keeps coming to my mind is we say based solely on, but then so it's not solely on anymore, it's actually two things. And that's confusing to me. Because we can't say based solely on or co-occurring with community, because solely on is, I think, very definitive. Does that make sense? It's these things. So help me, if somebody can help me with that. That's where my mind is right now. Representative Riley.
Would it be possible for our sheriff representative to come back and just maybe give us some input on this? Because it seems like that would help us a little bit.
So this is more about the petition than the sheriff. So maybe Tanya Keys wouldn't mind giving her thoughts on this? Yes. Thank you, Tanya.
Thank you, Madam Chair and Committee. Tanya Keys, Deputy Secretary, Department for Children and Families. In terms of the proper grammar, trying to think in my head about what would be a better sentence structure. I understand the spirit of what's trying to be accomplished. I don't know that I'm an expert on grammar for that. But certainly understand the spirit, support the spirit, that we wouldn't want that in addition to any of those that would be solely based on that community or family poverty wouldn't be considered in combination with any. So I do understand the spirit of it and support that. Shall not be based solely on or co-occurring. I'm not a I'm not an attorney either,
Okay.
social worker. So I believe that it would be okay, but certainly would defer to revisers on a better sentence structure for the proper phrasing.
Jesse, do you have any input on that? Thank you, Tanya.
Sure. So it would be my opinion that the way it's currently written would allow that the petition could not be based solely on one of these factors, or the petition could not be one of these factors that's co-occurring with community or family poverty as written. If that is not clear in the current way, what could be done is a repetition of facts demonstrating harm shall not include any of the following in subsection 7A, I through 6, co-occurring with community or family poverty. I believe those two, the one before you and the one just stated, have the same effect, but if the committee believes the second one is more clear, then I'll leave that to the will of the committee.
Okay, and it may just be that I've exhausted my brain cells for today. Other discussion? Representative Humphries.
So I'm wondering why we don't just strike out community or family. If we don't want that to be one of these, then, because what I'm trying to think of is if there were any two of these factors that were together, we're saying that that would be an okay reason in the petition. Like, you know, if there was a mental health condition and you know, disability, I mean, that could be a reason, or let's say the age of the parent and a mental health. If there were any two of these, we would say it was okay. So if we don't think community or family poverty should be ever paired with any of these other ones, why don't we just take out the language? I don't know. I mean, I'm again talking, Jesse. I mean, I don't know. I'm just asking if that would do the same thing or not.
So it'd be my opinion that if you just struck I, community or family poverty, then that would allow a petition to use community and family poverty as a sole basis.
You're right.
Okay, other discussion? Questions? This is a hard one. I understand the intent. I do, and I agree with it, like making that clear. I guess my thinking was that it was clear in the definition that it was for poverty would not be considered. Okay. Do you want to, Representative Esau?
I keep rereading it with how it got amended before, and because I understand what at least I think I understand what he's wanting to make clear. Demonstrating serious harm shall not be based solely on community or family poverty, and then we say isolation, or we change it to be based solely on or co-occurring with community or family poverty, and then we start listing them. I don't know if we're changing anything by putting it up there. So do we want it to be listed so that it's very obvious community or family poverty is simply not enough of a reason? Or is it better to have it in the paragraph? And that's where I keep going back and forth. And if I was voting in my mind, I might pass because I don't know. I'm like you. I think my brain cells are, yeah.
Okay, so Jesse, so co-occurring with community poverty, that means that they can have poverty and anything else, any of these issues, and it would not be a reason for removal based on those. So We would be saying that it cannot be community or family poverty and isolation, community or family poverty and the age of the parent, and crowded or inadequate housing, and non-felony drug crime without harm, and mental or behavioral health conditions and disability. That's what we're saying is not a reason for removal. Is that correct? Yes, Representative Mosley, and then Representative Burke.
Sorry, I was not here for when all of this was discussed, so please forgive me for my ignorance. But if there's 3 of those incidents, the child can be removed from their home. It's just there can't be 2 of those instances that's listed above that we're discussing, just for my clarity.
Just for clarity, it was based solely on.
Okay, and now it's, okay.
It was just those instances alone, based solely on these. And now with the amendment, it cannot be one of those instances alone or
one of those
poverty and one of those instances.
Okay, thank you.
Okay, Representative Burkamp?
Yeah, and you probably just answered my question, but I'm a little slow too, so.
I'm just getting it myself.
Slow as what?
It's starting to click. Yeah. Wait.
Because the original intent of the bill was to not punish somebody for poverty,
Correct.
So it's like you put that in with all these others to say it has to be this and something else. But if you take it out, then you couldn't remove somebody solely for what's now listed, or did I miss the? So like, because if you leave the language of be based solely on or with poverty, so now like you don't have poverty in the bucket, so you couldn't take somebody out if it's due to isolation or substance abuse. Am I thinking of that right? You still have to have 2 of the ones below.
You could do either one. You could go ahead, Representative Humphreys.
Well, so, and Jesse's answer to my question, if we just took it out, but isn't it in there? I mean, that's what the whole bill is about, a lot of it, right? That neglect isn't, but this is about the petition. Sorry, we're all kind of talking out loud. I mean, we're all kind of thinking out loud is what I meant to say. Okay, I think the base solely on kind of clarified it for me that that it was clear it can't just be that. And that took care of it because I didn't like the way it said alone, because then that did make it sound like 2 together. I don't know. I probably I feel like the base solely on took care of that issue that we were talking about the other day, but yeah.
I think I do too. I understand the intent and wanting the clarification, but I think it muddies the water when we have based solely on one thing and then we add or co-occurring, which means 2 things. And I think that's confusing in that section. If we could figure out another way to add that into the paragraph, I would be okay. I would be more okay with that than saying 1 reason or 2 reasons. Because that's what we're doing, 1 reason or 2 reasons. And I think that muddies the statute a little bit. Representative Neighbor.
I would just like to cause more communication conference. My question is, family poverty is one issue. Why do we need community? Because we are looking at the child in a home. And if it's family poverty, I'm not looking outside that home necessarily for the community necessarily. We're taking that child from a family. And if it's because of poverty, then it has to be associated with something else. But why do we need community?
We did have that question on Monday, and I believe Tanya answered that question. Are you available to answer that question again? Refresh our memories.
Her brain's going dead too.
Yes.
Thank you. Hi, Tanya Keys, Deputy Secretary, Department for Children and Families. So and when we were looking at other states and in conversations and dialogue to clarify that it's the community or family poverty is that we wouldn't want someone to view a community or see a neighborhood, or for example, a zip code, or a part of a greater metropolitan area. We wouldn't want community poverty to be a reason alone that a petition is initiated. So it's just an extra safeguard or an extra descriptor on how poverty might be interpreted or viewed or considered in thinking about writing a petition. So it's just additional clarity.
Okay, Representative Neighbor.
I understand the poverty issue overall, but we are looking at a child in a home. Is that not true? I mean, may I
Madam
ask?
Chair, Representative, yes.
Okay, so if we're concentrating on that child in a home, then and also in, let's say, a behavioral health condition, that would be two things. So you could look at that, right, because it wouldn't be solely based on.
As the bill is now, but if we amend it, we could not. Because it would be co-occurring with poverty. Okay. Does that make sense? No, I want to make sure you, did I misunderstand your question?
I'll work it out in my mind.
Okay, Representative Johnson.
Thank you, Madam Chair. My experience is that a community is a very important factor. I have dealt with some of the projects in Wyandotte County. I remember coming into the Hmong community when they first moved in from Vietnam. They were treated as large families. And I would really think that there are times that we look at neighborhoods and we make an immediate assessment in our heads, and I want to avoid that. And I've seen that happen with police and whatever. We judge a neighborhood. And so I'd like the community in there. Thank you.
Okay, other discussion? Questions? I know this is hard and this is heavy and poor. Representative Mosley just joined the very end of the conversation here. So we spent a lot of time talking about this on Monday. Revisor Jesse.
Thank you.
I almost demoted you.
Thank you, Madam Chair. I do have to correct myself on the amendment. So you would want the community or family poverty not to be struck, so it would remain one of the ones it could not be based solely on. So I answered Representative Humphreys incorrectly.
Okay, so the amendment should not have that line through there. Is that correct?
Correct, in
Okay.
the little I.
Okay, so it remains a reason for not based solely on. So that would be co-occurring with community or family poverty, and then one of that is community or family poverty? Yeah, that would be a double whammy. That would be, it would be I don't know that that would make sense. Is there any place else where we could include, the emphasis on poverty not being a reason for removal that you could suggest in the paragraph above and leaving the base solely on with that list? Because I think Representative Roser, while she's thinking.
So, sorry, line 22, starting at line 22, demonstrating harm shall not be based solely on, and then if we had I as community or family poverty, and in addition to, and then I being isolation, 3 I's being age of the parent, and then if we tacked it on to the end of I instead, because the point was to do the co-occurring, right? And so if we left it as be based solely on, line 24, community or family poverty, in addition to.
Okay, so my question? So my question on that is that if this is a standard of removal, then all of those reasons would have to occur with poverty in order to remove, if we moved it over like she's suggesting?
So in sub I, after community or family poverty sim, if you included and, then that would eliminate the based solely on category, right? And make it the petition community poverty and one of the following. So it wouldn't be the two options.
So if community poverty didn't exist, or poverty, or family poverty didn't exist, how would they remove? Or I guess it wouldn't, I guess it would just be based solely on, they would have to have more than poverty. Yeah,
Okay.
go ahead. No, I just want to make sure I'm understanding that correctly. Yeah.
So, Madam Chair.
Yes.
One way you could revise this amendment would be to say, not based solely on, and then keep the list as is, and then add a little x to say one of the above co-occurring with community or family poverty. So then you have the very last option that says any of these and community and family poverty. Can't be based solely on this last factor. That includes these two items because it's the one factor with the two pieces in it.
Okay. That is clearer to me. Thoughts on that? I see heads shaking yes for those of you online. Representative Carr, that would be your amendment. So your thoughts?
Thank you, Madam Chair. Let me say this. At some point last evening, I somehow questioned the level of integrity of my IQ. However, I'm proud to say that you guys have vindicated me, being that it's taken us this long to come up with something that was adequate. So I think that works, or whatever satisfies the justification. The intent, of course, here is that simply stating that someone is living in an impoverished condition is certainly not grounds for removal or neglect. And that's what the intent is. However the body is comfortable with the language, I know I'm okay with, as long as we have the understanding that that we are simply removing living in impoverished conditions as not being grounds within and itself or in connection with any other item as being grounds for removal. And so with that, if there's no more discussion, I move my amendment.
Okay, so we can't move the amendment because the amendment is right there. Yeah, so let me, when she gets back, I'm going to ask if we can do maybe a conceptual amendment instead of this amendment.
Okay.
If that would be okay. Yeah. Because I think the conceptual would be easier than trying to change this amendment. And then do you want to leave community and family poverty? We would want to leave that as a standalone reason, correct?
Yeah,
Yes,
yeah.
that's, okay. Is there any other discussion while we're waiting on Jesse on this? So I think you want to make a motion to do a conceptual amendment? Would probably be easier, Jesse, do you think? Or instead of changing this one, just do a conceptual one with section X? Either way. Okay, so however you want to word that.
Either way. So I move that we do it. Either way, Jesse says do it. It's easier for her.
Okay, there's.
May I?
Yes, you may.
Okay.
Jesse.
Okay.
Bail yourself out.
So what the amendment, as I understand it, would be, is that you would have based solely on, as adopted in the other amendments, I, keep community or family poverty as is, keep I through IX as is, strike the or in VII, and then amend or after the AAT, add a new little x that would say one of the above facts co-occurring with community or family poverty. And that's how I understand the amendment.
Is there a second on that? Okay, Representative Riley. Well, we got it officially now, so I just want to make sure. Representative Neighbor, you have a question?
Had renumbered 28 and 29. I'm not sure this would be an X. It'd be a 9. Is that correct, Jesse?
It's 10.
Because we took out substance abuse.
Right, and that would be technical cleanup.
We're going to give her the technical cleanup when we move the bill out.
X
Yes.
we might want.
Yes.
Yeah, it'll be, yeah.
Call the question.
Okay, call the question has been heard. We are going to move, we're going to vote on this amendment as stated by Jesse. All those in favor say aye. Aye. All those opposed say no. The ayes have it. The amendment, I was going to say conceptual, but the amendment passes. Okay. Okay, any other discussion on the bill? So we have had a lot of amendments. Are there any other amendments or discussion that we'd like to have on this HB 2132? Any thoughts on the bill as itself, as amended? Representative Neighbor.
Thank you, Madam Chair, and I want to commend you for all your hard work and dedication in trying to make something very difficult understandable by a lot of people and agencies. My problem with this bill is that we've amended it on one day, or we heard amendments we didn't amend, and now we've heard more to clean up the amendments that we heard before and to keep changing. Right now, if I look back on the history of bills of this nature, like 367 that we had years ago, and we have found multiple issues that were wrong, and it was a big, big issue at that time, and it would be on the proportion, I believe, of something that we're doing here. I would rather see a subcommittee look at this and review it and bring it back next year. I think it's a great opening. I think that has many possibilities, and as I said, you worked your heart out. Has nothing to do with the work that you put in and dedicated. I'm not comfortable with this being ready for prime time.
Is this the motion?
No, you said a comment on the bill.
Okay.
And so I'm not going to make a bad motion or anything like that, but it's just more food for thought, and I appreciate that. Thank you.
Representative Esau.
And this is just a thought I had before she even said that, is I've been scribbling and writing to make sure I understood what we were doing as we're doing it. And I don't want to delay, if we do want to move forward with it, I don't want to delay it getting to the floor at the appropriate time. But I also don't want to see it die in the House either because of the fact that it didn't get to the Senate. Because I was wondering if we want to see the final version of what we've created and then vote on it Friday or Monday, in a meeting that's just for that purpose. But because I understand the representative's concern too, I want to make sure we're getting it right, but I also don't want to delay it happening.
It would have to be Friday or tomorrow because we've got to get the bill out to get it over to the Senate to give them time to work it. Representative Owsley?
Thank you, Madam Chair. And as the ranking member, I feel like I need to chime in here and just say that, while I respect the concerns raised by the two speakers ahead of time, I don't share the concerns. I'm fine with voting this out today. We've seen most everything in writing. Pretty clear, less, a little conceptual adaptation in the last one. This is always the first step in getting a bill, passed. And, if we have strong objections to it or major concerns, when we do see it in writing as a new bill, and I thought one of you was going to go as far as to say a substitute bill, but I didn't think we were there yet.
We are going to be making a motion to do a substitute bill because there are so many amendments so that we can read it clearly. So that is part of the motion I've asked.
But I would just say that we still have the floor. We still have, Senate and I'm sure a conference at some point in time. So I wanted to respect the concerns, but state that I didn't share them. Thank you.
Thank you, Representative Owsley. Representative Johnson?
Yes, I move to pass out House Bill 2132 as amended by the committee, and that the reviser prepare the bill as a substitute bill, and that the committee grants discretion for any necessary technical changes.
Is there a second? Second, Representative Owsley. Any discussion or questions? Okay, all those in favor say aye. All those opposed say nay. The ayes appear to have it. The ayes have it. The bill passes out to the floor. Okay, that is all I have for today. We are done 10 minutes early. I just want to congratulate you. That is great. And I just want to say thank you to each of you for the work that you did and just thinking through this. I did want to allow 2 committees. I did not want to just try to push this through. I loved the discussion. It was amazing. The stakeholders, I talked to them a lot, argued with attorneys a lot, which was really fun. I do appreciate the district attorneys that came to the table and weighed in as well. And Mr. Klump, who represents the police officers, and appreciate his input. I think we have a good bill. I am very excited about that police protective custody piece, where DCF is creating that line for police officers, that dedicated response for police officers alone. I think that is going to make a huge difference in our child welfare. So with that, is there anything else? Okay, we are adjourned.